Victim impact statement versus parole protest letter. What no one tells victims: if you lost someone to a drunk driver, what I'm about to tell you could determine whether the person who killed them walks free. This is what victims are never warned about. Hi, I am Sarah. Most people know me as Mama Bear. I lost my only child, Dr. Kenley Jean Rainey, to a repeat drunk driver. There is something the justice system does not clearly explain to victims. Because if it did, fewer people would trust it. Victims are led to believe that victim impact statements, commonly called VIS, is where justice happens. Once you give it in court, your loved one is finally protected. That is not true. What no one explains is that your words can be sidelined or ignored when parole decisions are made years later, behind closed doors, without you ever knowing about it. No one explains the difference between a victim impact statement and a parole protest letter. No one explains that parole is not about your loss. It is about the offender's future, not yours, the offender's. This presentation is about what victims are not told, what is withheld, and what you must do if you do not want to be erased from the process. Victim Coordinator and Liaison Grants, VCLG. Victim Assistant Coordinators, VACS, in Prosecutor's Office, typically loyal to who pays him. The DA's Office Crime Victim Liaison, CVL, within the law enforcement agencies. These professionals are responsible for helping victims understand their rights, connect with services, and navigate the justice system. That is separate from parole liaison, connected to the Federal Bureau of Prisons, POB. Victims should be assigned to victims' rights representative at the discovery and trial and sentencing stages. This person is responsible for explaining rights, guiding them through court procedures, and helping them prepare and submit a victim impact statement, VIS. In my case, that did not happen. You can find information on victims' rights on this channel. After conviction, when the offender enters prison, victims should then be connected to a victim liaison through the Department of Justice or the correctional system. This liaison is supposed to help victims understand incarceration, parole eligibility, notification systems, and how to continue participating. Victims should be clearly told who their point of contact is, how parole works in their state, where and how to register for notifications, and what steps are required to stay informed. In theory, the system should ensure that the victim's voice is heard throughout the case. What actually happens, many victims are left without guidance once sentencing ends. I am still waiting for a call from a liaison. Victims are often not clearly told who their contact person is after conviction, or even that there is one, like me. The transition from the courtroom to the prison happens quietly, and victims are expected to somehow know what to do next. Notification is not automatic. Instead, victims are expected to locate the correct government portals on their own, register with appropriate agencies, determine which systems apply to their case, and track deadlines without clear instructions. Deadlines can pass without notice. Parole reviews can begin without victims realizing it, and parole decisions can proceed with only the offender's support system present. Let me say that again. With only the offender's support system present, not you. That is what the offender wants. By the time victims discover what is happening, they are often told, well, the deadline is already passed, sorry. The online maze victims face. Much of this process is pushed online. Victims are told to register, but not always told where. They are sent to fragmented, confusing, and sometimes outdated websites. Each agency has its own portal, login, terminology, and rules. Victims are expected to read legal language, interpret eligibility requirements, and figure out which system applies to them. Often while grieving, there is no single roadmap, no unified system. Every state is different, and no pause button if a victim gets it wrong. The system assumes victims will figure it out. In my opinion, they do not care. In fact, I am sure the offenders and their families who are guided through this process want victims like you and I to disappear. As always, the criminal has all the rights and help. Victims have to fight for everything. Why this matters in parole cases? Well, parole boards do not automatically revisit trial victim impact statements. Instead, they are often focused on institutional behavior, like SB 676, credits, program participation, disciplinary history, and release plans. Unless victims' family and friends submit parole protest materials and remain involved, their voices may not be part of the review at all. You must contact the parole board to learn its rules and regulations, as each state is different. Do not assume. That is why understanding the difference between victim impact statement and a parole protest letter matters. I found I needed to fly down a few days or weeks early to record a victim impact statement. And after requesting it, I was the only one allowed to fly back to conduct an in-person VIS statement at the parole hearing. You may have to Zoom. It's very confusing. It's not like it is on TV. The victim impact statement, VIS, is presented to the judge at sentencing. If there is a trial or a plea deal, it makes no difference. That is between the prosecutor, the criminal, and the defense attorney, not the victim. Typically, you find out after the plea deal, as I did. Typically, it should follow the offender to prison. The parole protest letter is addressed to the parole board years later, which anyone can send in a protest letter. One without the other can leave a critical gap. The roadmap victims should know. First, give your victim impact statement at trial or sentencing. After conviction, register with the appropriate victim liaison or notification program. Do not assume this happens automatically. It doesn't. During incarceration, prepare instead of staying silent. Learn, understand your state's parole process. Understand what victims are legally allowed and not allowed to do. Track deadlines carefully. Many occur months before the parole review. Keep records, contacts, and documentation organized. When allowed, ask family, friends, and community members to be ready to submit protest letters. Believe me, this can be confusing. But being a mama bear, that is what the system does not want you to be. They want you to disappear. When parole reviews approaches, submit your parole protest letter and stay engaged throughout the process. Becoming a mama bear. Many victims, including myself, have had to repeatedly request contact, follow up, and wait for basic information. That is why victims must become what I call a mama bear. You follow up, you document requests, you ask questions. You do not assume the system will protect your voice without effort. Victims have rights, but those rights often require persistence to be honored. Personal reality. The man convicted of killing my son is currently incarcerated, and his parole eligibility dates is approaching in December 2026. Do not believe the date they give. They can change it. If I do not remain involved, the only voices the parole board may hear are those advocating for Dennis's release. The offender and their family receive ongoing support and notification. Again, victims are expected to navigate the system on their own. Follow me in upcoming videos as I document my fight to stay informed and oppose parole. That is the reality victims face. If this helped you understand how parole works in DUI cases, it matters. What you see on television is not how the justice system treats victims of drunk driving. In parole decisions, knowledge is protection, and silence can cost lives. If this helped you, share your experiences. Connect with other DUI victims in your state through my channel. Learn how parole really works, because knowledge is power. The justice system on TV is a myth. Join other mama bears who are preparing, staying informed, and refusing to let repeat offenders be released without accountability. If this presentation helped you, subscribe, share your story, and include the state you are working in so others can learn from the experiences and stay connected. We can help each other. This gives victims a voice and a way to get information from those who experienced it. Because if victims do not stay involved, only the offender's voice may be heard. I am Sarah Brainey. Most people call me Mama Bear. Thank you.